Thank you, Your Honor, and I apologize that I was late.
Abraham, let me know if you have any difficulties with someone working from the other podium, okay? Okay, very good. Okay.
Good morning again, Your Honor.
Good morning, ma'am.
I'm going to start with the undisputed facts here, okay? Derek was barely 13 years old at the time of the incident. His birthday is August 26, 2010. The incident occurred October 12, 2023. He has a previous diagnosis of ADHD. He has been diagnosed with autism. I would submit to the court that he is emotionally and cognitively immature. I think that Sperry's deposition, specifically, I'm going to point your honors to page 12, pages 147 and pages 142.
Sorry, who are you referring to, ma'am?
Dr. Sperry's deposition.
Which particular deposition?
The first deposition taken in November 19.
Thank you.
Pages 12, pages 147, pages 148 confirms the fact that earlier in his life, specifically 2018, if we look at Dr. Ferretti's records, there was, that's when she believes that they missed the autism diagnosis, because there is an unknown diagnosis, and he's actually sent for evaluation, and that's when she believes that the autism was missed, right around the time that he was 7 years old. Now, Derek told the 911 operator that he considered suicide, that he was suicidal. And I know that Your Honor asked Mr. Borst exactly what he said to the operator. And in response to, why did you kill your mom? And that is at 3:06, and he responds at 3:10, I just didn't want to be here no more. I didn't want to live. I did not want to be alive no more. My stepdad has 2 guns, he has a Glock, and then he goes into the guns. But that was his answer to that question. Now, the fact that he does not know his own address.
Can I ask you a question?
Yes, sir.
And I really don't want to interrupt, because I actually agree with you on a lot of the issues here and a lot of the factors you're dealing with. But I see kind of a parallel where each time that he's asked, why did you kill your mom, by the 911 operator, he doesn't really get into why he killed his mom. And he sort of moves over into, my dad has 2 guns. The same thing happens at the police station when he's asked, why did you kill your mom? First, he, I don't want to use the word distracts, but delays by saying, can I go to the bathroom now? And then when they come back to it, he actually expresses the fact that, or questions, do I have to answer that question? Which concerns me, because it states suggesting, and it does seem to show a knowledge of his ability to say, I don't want to talk about this. And a desire through the course of the evening to not talk about that specific matter. So that's why I asked Mr. Borst what his recollection was of what your client said on 911.
Your Honor, I think the submission that he didn't want to talk about the incident, I don't want to say I would dismiss it, but I would give it very little weight, only because he exhaustively talks about the incident. He gives great detail about the incident.
Except for that one thing.
Except for that one thing.
Yeah.
So, I mean, I would submit either because he doesn't have an answer because he didn't do it, so he doesn't know why, because he didn't do it. That's one, perhaps, argument. I can't tell you why. Why can I tell you why? Because I didn't do it. That's one argument. Or the state of mind that he was in when asked that question at 11:37 or shortly after 11:31 when he calls was so compromised that he could not process that question, much like it was at 2:39 when the interview began. Those are 2 things to consider as to why he talks about suicide and not wanting to be on Earth anymore and doesn't directly answer that question, Your Honor.
Thank you.
Now, the fact that he doesn't, the items that he doesn't know that someone his age should know, his address, for example, the fact that he has to go outside to look at the apartment number. He doesn't not only know the address where he currently lives, he also doesn't know his father's address. He doesn't know his phone number. He doesn't know the fact that he has a signature or that he has initials. I think that's very telling, Your Honor, for somebody that's 13 years old. Now, the fact that he doesn't know what an attorney is, and the explanation that is given to him is it's a lawyer. And as we heard Detective Eloseni testify, a lawyer is a lawyer. Submit to the court, that's not an explanation of what a lawyer is. Now, there was testimony yesterday that he unavailably invoked when he asked for the attorney. Right after he says that can I wait for an attorney, which is what he asks, he immediately says, well, maybe not. And then at that point, Detective Elosegui says, listen, you're talking about an attorney at this point. If you want to talk to an attorney, if you want to wait for an attorney, we're going to stop the interview. And
Maybe not?
He does say maybe not, Your Honor.
Like maybe not, he doesn't want to wait for an attorney?
Correct. It's not a direct assertion of his rights. He's wavering. He's confused.
But then what do you make of the fact that the detective says to him, if you want to have a lawyer, I can't go further with this. Do you want to terminate this interview? And your client says, yes. I mean, that just seemed to indicate a very direct question, which implicates a knowledge of his ability to do it and a desire to do it. I got your point on the, I'm not going, we're not going to have this interview unless with an attorney present, or I can't do this if you need to have an attorney present. And I've got that. I don't think it means quite the same thing in terms of a coercive nature as you do, because he's already talking without a lawyer. And the officer seems to be explaining to him cogently that they'll stop the interview. So I'm sorry to interrupt you. But please continue.
The fact that there's no parental figure, I think really goes to the totality of the circumstances. The fact that there was no indication that he knew that he could have a parental or guardian figure present, I think that's very important. I think the fact that the last time that he attempted to have an adult present after the incident occurred, he was denied to do that. And that happened during the 911 call when he asks if he could answer the phone, and he's instructed not to answer the phone. That's the last time that he would have had contact with an adult that he lived with, that's Mr. Ramos, and he was told by the operator to not answer the phone. I think after that, well, I know the evidence shows that after that phone call by Mr. Ramos, the only other person that he could have talked to was his grandmother that was on scene, his father that was on scene, his uncle that was on scene, but there's no indication that he even knew that those individuals were on scene at all. I think his grades, Your Honor, are really not as supportive of the state's position as in terms of his intellect, as they would like it to be. And specifically what his father says about his grades. There's no personal knowledge about his grades. There's no evidence that his father even could log into the school system to see his grades. And I think when we look at all of his grades and the trajectory of the schooling, it's very evident that it's a roller coaster.
I have to disagree with you on that. I'm sorry. But I mean, in second and third grade, in first grade, he had far more absences than you would expect from a first grader, which I always think goes to the parents as opposed to the student.
I think the medical record further explains his absences, Your Honor.
And then grade 2, 22 absences, 3 in third grade. But he went from a lot of CDs, couple of Fs in second and third grade to by the time he got to 7th grade, he's in honors biology and gets an A. Language arts, he gets an A. Honors algebra, he gets a B. Finishing up the year with 5 A's and 2 B's, and but still 20 absences. So I have to question the statement that it's a roller coaster academically. It actually seems to be a rise in his ability to be able to function at school and to obtain the grades.
Your Honor, I submit to the court that if we look at the medical records, he was medicated. and he should have
Well, I'm
remained.
not so sure about that, because the indications I got early in this case was that he was prescribed Focalin,
Focalin, yes, sir.
but that he wasn't taking it at
He took
school.
Focalin, Your Honor, for over a year, and
Yeah.
that's supported by the medical records. And then Dr. Sperry also confirms in her deposition that he stopped and he should have continued. I think Dr. Sperry also answers the question as to what, I understand the court doesn't agree, but as to what I categorize as the roller coaster in grades, why, what he was doing to get those grades, what he was using, what tools he was using to get those grades. And it wasn't coming from his brain, let's just say that, okay? So I think that.
Sorry, when I ask Siri or I ask ChatGPT, gee, what's ABC? And it tells me that, you have to read it before you put it down on the paper for the teacher. So the research tools people are using now may be a little bit easier to use, but I'm not ready to say that or accept that just because he uses ChatGPT or asks Siri for an answer to an algebra question, that he's diminished as a student. That's for the teachers to watch out for. He's getting A's and B's. So I'm not ready to accept that the use of AI, and it may on the long term, but I'm not ready to accept in the short term that it makes him less intelligent or less capable of understanding his Miranda rights. I did see that. I did see what she had to say. I'm not sure I go to where she does.
Right, I think that that's a broader issue. I really do. Because I think that there is a huge difference in how, for example, I learned information and regurgitated it versus how somebody now knows or purports to know the information and presents to know the information. So, yes, Your Honor. So I think that to say that he was using tools to make him give an answer, and we're going to dismiss that as he still had to read what the tool had to say, that's still not him figuring and rationalizing and analyzing to get to that conclusion. All he's doing is inputting what somebody else is asking him to do, asking his brain to do. Derek, analyze this and give me an answer. Well, I can't do it, so let me ask somebody else to do it. And then I'm just going to tell you, regurgitate essentially what that other tool is telling me.
And how is that different from just going back to ask the teacher, hey, I'm having problems with this question. Can you show me how to do it? And then maybe it's not the same teaching methods, but how is that different when he asks Siri to give him an answer to an algebra question? Look, we're not going to get a complete answer on this. All I'm saying is that I don't go to the very same place that Dr. Sperry does on this. And as long as, if you want to talk some more about Dr. Sperry, I'd like to, because she utilizes the diagnostic tools of speaking with the father and the grandmother to come to her conclusions about there was not an appropriate early diagnosis, okay? But we're dealing with the very same person who sat in the police car and told Detective Alosagri what a brilliant child, how intelligent, respectful, brilliant his Derek was, moments before the detective walked into a room to ask him if he understood and wished to waive his Miranda rights. So I'm finding kind of a conflict there where Dr. Sperry talks about all these, I don't want to say deficiencies, but overlooking things that a parent should have seen for a potential diagnosis, compared with his, I don't want to go, let's go into specifics. I mean,
I can address that and then go back to
yeah, but I mean,
kind of the flow of where I was going. But
we're going to come back to this because there's just some difficulties that I have with Dr. Sperry.
I think in discussing Jose Rosa, Your Honor, hindsight is 20/20, and it's very important to highlight the fact that he is speaking on things that he doesn't know about, and it's clear by the actual records. He's not a straight student, so
that's the point. If you're taking if you're doing an evaluative tool with a parent, and you're now telling me this is a parent who didn't have that much time with him, doesn't it undercut Dr. Sperry's reliance upon that evaluative tool?
Depends what specific portion of that tool this court is referring to. So, for example, if we're talking about the grades, no, it doesn't, because since it's been the father that's had to go to all these locations to actually obtain those grades. So he's seen now the grades. He's seen now all of his kids' records since he was born. He didn't do that before. So if we're talking about that information, then no, it does not undermine it. If we're talking about information of at what age should he speak,
Yeah.
was he delayed in speaking, I would say partially, I would agree, and if I might finish before I lose my train of thought,
Yeah.
I would say partially. However, the grandmother, she was there every step of the way. She was there for Dr. Sperry's use, and she did. So I would say the grandma is a wonderful source of information because she raised him. He lived with his grandmother, but up until he moved to Amelia Oaks.
So let me ask you this, because as we look through this, you have an officer who's going to go speak with a young man, okay? And should be on the lookout for any type of deficiencies in comprehension and the ability to waive Miranda's, because that's what the case is asked for. Yet he walks in there with this glowing review from someone who, fellow law enforcement officer, who gives a glowing review as to the intellectual and emotional capabilities of Derek. Just 20 minutes, 30 minutes before he walks into the room to talk to him on this. What do we do with that?
First of all, Your Honor, I think that the word brilliant was never used, but I do agree and concede that when Jose Rosa, it says he is a straight A student, Detective Elosegui took it for exactly that. He is a straight A student. Should he have delved a little further? I think he should have, but he didn't. And the fact is that statement's there. He said it, it's not true, and he took it for face value. When you look at the totality of the circumstances and you look at the fact that there were other individuals there, and in fact, there were other individuals there that were being questioned, for example, by Detective Mahela, right before the interview happened. There were more opportunities to gain a meaningful background on this child by somebody that actually lived with this child and was actually there that night. So I think that there were other tools that could have been used that weren't, in order to just gauge background, not just almost 9 minutes of an interview.
I'm sorry to take you out of your
Sure.
training.
So I'll say one quick thing on this point.
Sure.
Looking at the totality of the circumstance, you keep saying the dad has the only review of his son. I mean, what else is the dad going to do? I mean, his son is potentially being accused. The cops are speaking to him. I think that you also have to factor that into what Ms. Jose Ramos was saying about his son, and the detective should consider that as well.
Yeah, and it's a shocking kind of circumstance too. And the dad very clearly said, I cannot conceive of this happening.
So,
With this child, he said, no psychological problems, down to earth, respectful, very independent, mature, respectful again, several times.
but he also said mature. When he said mature, he said mature for his age. And I think that's what he said in the first interview. He said mature for his age. He knows how to do things that a 13-year-old could do, maybe.
Which again, I would submit that there should have been a red flag when he's asking, when Elosegui Gonzalez is asking him to initial, and he says he doesn't have initials. Or when they are saying, give me your full name, and he asks middle name too, of course, your full
Or
name.
his address and telephone number.
I mean, a 7-year-old, my child knows his phone number. I know who he lives, a street name, 1,000%, what school he goes to. He knew what school he went to. He knew that. There were just certain things that he just did not know that I think should have raised a flag to these seasoned detectives.
So why do you believe it did not?
I'm sorry?
Why do you believe it did not?
Because first of all, he said, Detective Elosegui multiple times testified that he did not think that there was anything wrong with that. He said it back in December. He said yesterday that he still believed that he understood what he was being asked and that there was nothing wrong with him not knowing to him.
I don't want to take you out of your pattern. There's some specific things I want to talk to you about this and the focus that I think the cases require, but I don't want to take you off of the pattern that you want to use. So
I think speaking on the obedience that he exhibited, compliance, he's very obedient, he's very compliant. He yesed his way through since 11:30. In fact, when he was on the phone with the 911 call operator, Your Honor, the police first arrived on scene at 11:36 p.m. I would submit to Your Honor that those 5 minutes before his takedown are extremely important, because that could have really ended even more tragically than what we have before us. They didn't go inside. They didn't know when to go inside. He's screaming, should I go outside? They're opening the door. There's a confusion there. And my point, and what I'm trying to highlight, is the fact of how obedient he was, how compliant he was. Now, and as a point of reference, I'm talking between 11:36 p.m. when they first arrived and 11:49. We could look at Santos Concha's BWC for the takedown at 11:49. Now, the traumatic event that took place, it's undeniable that death is traumatic, whichever way, I'm not going to repeat what I said yesterday, but whichever way you look at it, whatever theory of this case you have, he had undergone a traumatic event. The amount of police presence, I submit to Your Honor, Detective Rico's RICO BWC's, Moya, MOYA BWC, which is in evidence, Acosta's BWC, we could see the amount of police presence. And he's witnessing this police presence and everything they're doing from Gutierrez's cop car since 11:52 p.m., 53 p.m., when he's placed inside of it. He's watching all of this unfold. The amount of time that he spent in the car from 11:54 p.m. until roughly 2:18 a.m. I submit, Your Honor, to Detective Gutierrez's BWC. It's lengthy, but it's very, very telling, especially his second BWC, when we look at everything that happened from when he left the headquarters in Hialeah to when he got to the JAC. And I'll highlight some of those timestamps a little bit further. In terms of the interview, the detectives being armed, the detectives being significantly bigger than him. And when I say bigger, I mean height, weight, the fact that obviously he wasn't allowed to leave. I don't think it's in dispute that he was in custody. The fact that he's offered candy and Taco Bell after the fact, I would submit to the court as perhaps a reward. And maybe that wasn't the intention. Maybe that wasn't the intention of the detectives, but it's, yes, sir. I see you looking.
I'm just puzzled because how is it considered an award when it's not mentioned beforehand? In terms of a coercive nature, it'd be like, hey, if you talk to us, you get some Taco Bell. That could be construed as coercive. But as I gathered from what I saw, it was, hey, you hungry? After he had given the statement.
Your Honor,
How do I look at that as coercive if it's not mentioned until after?
If we listen to Detective Elosegui's BWC, specifically about 3:06 a.m., the manner in which Detective Gonzalez mentions the candy indicates that Derek knew there was candy there. Derek had never been at that station. That was his first time at any station. He had not ever had any interaction with law enforcement, certainly not at headquarters. I didn't know there was a bowl of Jolly Ranchers at headquarters. Apparently, there is. And the manner, the body camera speaks for itself. And I would direct Your Honor to 3:05, 3:06 in the morning and listen to what Detective Gonzalez says.
I'm sorry, ma'am. You're suggesting that there's evidence that your client confessed so he could have a Jolly Rancher. And I just don't see it from this evidence.
I'm suggesting that he's a kid like candy. And I'm also suggesting that in the totality of the circumstances, although a nice gesture, it was an unnecessary gesture. And I'm suggesting that the body camera speaks for itself. The entire time pre-interview, during the 911 call, during the interview at headquarters, and after the interview, he was suicidal. Your Honor talks about the Baker Act and that process. I submit that Officer Gutierrez's BWC, the second one, specifically starting at about 5:40 a.m., there are two individuals that are interacting. It's a male and a female at the JNC. And there's a conversation that happens behind closed doors between the female and Derek. We don't have access to that. We have no idea what happened, but what we do know is that when she takes him out of that cell, she says he needs to go to the crisis center. I think the elephant in the room is he's suicidal at 11:31, he's suicidal at 5:40.
No, ma'am, I don't have an indication he's suicidal at 5:40. You don't have that person coming into court to testify. You don't have the substance of that conversation and an abundance of caution. And I actually, based upon the circumstances shown in this case, I think it's an appropriate move to take him to a crisis center. because he's been through a traumatic event. He's expressed suicidal ideations early on in the evening, but did not follow through and doesn't show any indications thereafter. But it does make sense to send him to a crisis center, particularly in light of his age. But please, you cannot tell me that conversation at 5:40, he threatened suicide when you don't have anybody presented as a witness who was in that room. I'm not ready to make that jump.
Judge, at 6:10:30, Gutierrez's second BWC, the male officer says he is going to the crisis center. At 6:10:50, Gutierrez asks why. And at 6:10:51, the officer says, because he tried to kill himself. Again, I submit to the court that the Detective Gutierrez's BWC, the second BWC, is extremely important, additionally, let me say, Detective Gutierrez, this was his first time Baker acting someone. He had no idea. If you look at that BWC, he's on the phone with his supervisor the entire time. He's crumpling papers that he is filling out, throwing them away because he doesn't know what he is doing. He's being guided on what to do the entire time. He later admits at deposition that he had never done this. When he gets to the crisis center, in fact, if we listen to his BWC, which again, it is so important, he says to his supervisor, no, they will not take him. They need to Baker Act him. So there's still, when I say they, perhaps ignorance is, he didn't know any better. It's not his fault. But he genuinely was trying to prevent Derek from going into the crisis center because he thought where he needed to be was at the jail because that's what he was instructed to do. He had only been on the force for months at that point, and he honestly, he didn't know what to do. He was being guided on what to do, not only by the JAC staff, but also by his supervisor, and that's evident on the BWC. We could see his screen, his phone screen on the BWC of who he's talking to, and he admits who he's talking to. He, in fact, fills out the form wrong, with the parental information wrong. I think all of this is relevant, specifically to his state of mind around between 2:39 a.m. and 3 a.m. on the 13th. There's no toxicology performed, Your Honor, on Derek. There's no knowledge of how much he had slept the night prior. I mean, we know that he was in the cop car for almost two and a half hours, but we don't know what happened the night before. I think that the fact that he's told that if he wanted a chance to explain himself and speak to the officers, the only way that he would be able to do it would be then, I think that's highly suggestive, and we know that to not be true because he could have spoken to the officers at any time if he wanted, and they'd take a statement with his attorney, with his father. That was not the only time that a suspect or a defendant is allowed to give a statement to law enforcement, and it happens all the time that suspects give statements with their attorneys present.
Really?
Yes.
I'm sorry because I keep hearing that, and I'm kind of wondering if you would have walked into that room at 2:49 and said, go ahead, Derek, just tell him about how you killed your mom. Whether you as a lawyer would have said, yeah, let's waive your rights right now, 3 hours after this, and you go ahead and tell him. Because I've been around this building 45 years, and the only time I ever see that is on a 3.850 ineffective assistance of counsel motion. So I find it very difficult to believe it, and I don't know that it's coercive. I think your point is that by telling him the only time we can talk to you is without a lawyer would be now, you urge that that's coercive.
To him, Your Honor.
Right, to him.
Yeah.
In reality, that's the only way it's going to happen. Okay, but is it coercive to him? But then I have to look at that statement in the face of everything else that's going on. Sorry to take a digression there, but
then just to address a couple of specifically, actually, before I address Mr. Borsch's couple of his comments, the fact that he understood and he said yes to every single line of, when I say line, the 6 paragraphs that are in that form. I would point, Your Honor, to paragraphs, specifically 3, paragraphs 4, and paragraphs 5 when there is no verbal acknowledgement, there is a nodding of his head. There's no question, there's no explicit acceptance or acknowledgement by Derek that he is understanding what he is reading. Now, in terms of, Mr. Borsch said that he was made to feel comfortable in the back seat of the police car. First of all, Detective Otosegi could not even testify whether he was cuffed or not. I would go back to the BWC, Gutierrez's BWC, extremely, extremely important. He's nodding out. I mean, he's falling asleep. I don't know, I think it's speculative to say that he's calm because he's not screaming or kicking the window. I think that it's speculative to say that he's reflecting when you can see that he's nodding out and falling asleep. Now, when he's asked, how are you? And he responds, I'm good. And this is where it would have been great if Dr. Sperry would have been here, because there's a saying, which I'm not going to repeat the first word, but it would have been great for her to tell before, how most people answer when you ask them, how are you doing? They say, I'm fine. And there's a saying in psychology of what FINE really stands for. There's few individuals that tell you, I'm actually having a mental breakdown right now as we speak. No one says that. Everybody says, I'm good, I'm fine. Now, in terms of open-ended questions, I would submit to Your Honor, I would say BWC speaks for itself. They are not open-ended questions, specifically those paragraphs that I just highlighted. The Baker Act, I think that I submit that Mr. Borsch's characterization of how it happened is inaccurate. And again, that this wasn't done in the abundance of caution. This was done because of his current mental state, which was assessed at the JAC. And if we look at Gutierrez's BWC, I think that's the best evidence of that. In terms of him inviting the police, sure. It should not have been a surprise to him that police were coming. But there's absolutely no indication that he would have inferred, because they're here, I'm gonna be questioned. He had no prior experience with law enforcement, zero. In terms of autism being a social and not a cognitive disability, I think that, first of all, if we look at Sperry's deposition from November 19th, specifically page 50, she explains how autistic individuals have a sense of a grandeur of intelligence, and others perceive them to be more intelligent than they actually are. That's only because they have specific knowledge on, for example, xenomorphs, or they have specific knowledge on things that other people do not. They appear to have a higher intellect than others, when that's in fact not the case. Mr. Scalzo can address the case law, Your Honor, but I would just briefly submit that, first of all, as under Ramirez, no question of custody, and looking at the totality of the circumstances, the waiver fails for all of the reasons that I just stated. Now, I agree that the case law supports that a 13-year-old can waive, but I think that based on what was presented here, this particular 13-year-old did not have the ability to intelligently and knowingly waive, and thus not voluntary. I think that Mr. Borsch doesn't want to agree that, I guess, the altered standard or heightened standard in BNP and JG, but I think that we do have to scrutinize these type of scenarios with these younger individuals, because they are not, and they don't reason the same as an adult. Their experiences are not the same. Obviously, age is not the same. Intelligence is not the same. And then when you have an individual that has specific, I don't want to say intelligence, I'm just saying knowledge, specific knowledge on certain things, but then is really immature when it comes to basic things that most people his age and even younger would know, then I think that that should be scrutinized with a heightened standard or greater standard. And I'll leave it to Ms. Descalzo if she wants to add anything. Thank you, Your Honor.
Your Honor, the only thing I want to add is that the cases that that Your Honor stated he was focused on, which is BME v. State and JG v. State, and which arises from Colorado v. Connolly, at least BMB and JG P, those two cases specifically state that part of the reason that the interview and the waiver was not voluntary, or why the interview was coercive, is because parents were not contacted when the Miranda rights were read, and that the juveniles were taken into rooms to be interviewed or to the police station to be interviewed, and that, you know, that is a significant factor that the court should consider, that a parent was not contacted.
But in JG, wasn't the godmother present? Isn't that the one where the godmother got together with the detective and raised a ruse that there was evidence implicating the defendant and there actually wasn't? Let me
I think in JG, I think that you're right about JG, that there was something.
I can see that that's what moved them, because they go back to Colorado versus Connolly, and really what I'm hoping I'm asking the defense to focus on is this. Yeah, nobody's going to draw a bright line and say, oh, you can take a confession from someone 15, but not 14. Or you can do it at age 10, but you can't do it at age 10, but you can do it at age 30. Nobody's going to do that. You have to look at the specifics of the interaction and the capabilities. Now, the parent being present is, to me, a big factor, and it was, I bet, to Judge Altenberg as well in BMB. But I'm looking for what was coercive. How did the officers take advantage of what you argue is a diminished capacity or comprehension of this young man?
Mm-hmm.
Because that's what Colorado versus Connolly talks about.
Right.
Because there you had someone who was psychotic, and the voices in his head
Mm-hmm.
were telling him to confess to the police. And the Colorado Supreme Court said, well, that's not clear and convincing evidence of voluntariness. And the United States Supreme Court told them, no, we don't do clear and convincing. We do a preponderance of the evidence, and we don't actually go inside the head as to why they're doing it. We go in, we take a look at, is there a condition that made them more susceptible? And did the police officers, in an improper fashion, use that in a means of coercion to get the person to talk? And that's what I'm looking for. Isn't that what I'm supposed to be looking for here?
Yes, Your Honor, but Colorado v. Connolly was different because the defendant in that case just walked up to police, started talking and confessing. And he then went back to the police station and again continued to talk. I believe that that's what happened in that case. And here it's a little different because you have, and I don't see any indication when I read Colorado v. Connolly that the defendant in that case was a juvenile. But here you have a juvenile, a minor, who has done something or is accused of doing something, is driven to a police station, 2.5 hours later is brought into a room. And you know, just the fact that he's there by himself in the patrol car this whole time, you know, the 911 call tells him, no, you can't answer the call when your stepfather, you can't talk to him, you can only talk to me. I think all of those things, and I'll submit that minors who have never been in trouble with the law, I think that they are compliant when they're given orders.